We're live.
All right, we're back in Senate Judiciary on February 10th at 11:48 with Katie McLinn from Ledge Counsel to talk about, I believe, the immunity piece on page 7, draft 2.1, based on a request from Senator Lyons about having us take a look at this. So the floor is all yours.
Thank you. Good morning. Katie McLinn, Office of Legislative Counsel. Just to maybe back up briefly and give you a 1,000-foot view of what this bill does. So this bill looks intimidating at 23 pages. It puts provisions in place. Currently, many of our laws are tied to recommendations from the CDC for immunizations. This sort of decouples that tie with CDC and instead authorizes the Vermont Commissioner of Health to make recommendations on immunizations. And so the first half of the bill makes these changes, and the second half of the bill, as of July 1, 2023, reverts back to the status quo of the law as it is now, meaning again, relying on CDC recommendations. And so what this does is it allows the health department to purchase immunizations that maybe the CDC has not recommended, but the Commissioner of Health does recommend. It allows insurance coverage for those immunizations, and it allows pharmacists and pharmacy technicians to administer recommendations that may not be on the federal CDC schedule, but recommended by the Commissioner of Health. So to the language you're most interested in, let's see, there is a new section in section 2. This section, again, would take effect on passage, and it would be sunset on July 1, 2031. So this is temporary language. This section in A sort of gives the scope of the type of recommendations that the commissioner could make. In subsection B, there are instructions about who the commissioner would have to consult with in making its recommendations. The commissioner would have to consult with the Vermont Immunization Advisory Council, which is an existing group, and it would have to consider recommendations from various professional organizations, including the CDC. And then in C, top of page 7, this is the language that falls within this committee's jurisdiction. So it states that a healthcare professional who prescribes, dispenses, or administers an immunization in accordance with the recommendations issued pursuant to subsection A of this section shall be immune from civil and administrative liability for immunization-caused adverse events unless the healthcare professional's actions regarding prescribing, dispensing, or administering an immunization constituted gross negligence, recklessness, or intentional misconduct. So this language basically says that if there is a healthcare professional who's acting within their scope of practice and they're following the Commissioner of Health's guidelines, and there is an adverse event, this would be not allow civil and administrative liability unless that professional was acting inappropriately. They're acting with gross negligence, recklessness, or intentional misconduct.
Katie, can I ask a couple of questions here? So I guess, I know there's a million variables to a hypothetical, but in this circumstance, let's say a pharmaceutical company comes out with a vaccine that does cause problems. That company is not immune from being sued. Right?
Under this language, correct, but there is another layer that we need to think about. So right now there's a federal program. It's the Vaccine Injury Prevention Program. And it's a program that circumvents kind of the current tort practice to go to court. And instead, it's a process where you hire an attorney, you pay a fee, and there is a designated amount of money. And if you have had a certain immunization and you have a certain reaction within a certain period of time, you could petition to have compensation from this program instead of going through the tort process. Right now, it's my understanding that all of the immunizations that were previously covered by the CDC recommendations are still covered by this program. The testimony from the health department has been that they could foresee that some of those immunizations that the CDC is no longer recommending may no longer be covered under this federal vaccine injury program. So right now, pharmaceutical companies would be prevented from liability under this federal program. If the program were to be rolled back, that's something Vermont has no control over, but potentially a pharmaceutical company that is currently covered under this federal program for certain immunizations, there wouldn't be a liability shield anymore, potentially. So when we're looking at this state language, this would protect Vermont providers who are acting within the Vermont recommendations as determined by the Commissioner of Health. This would not provide any coverage or liability protections from pharmaceutical companies. But if the particular vaccine in question is still covered by this federal program at the federal level, then a pharmaceutical company could still have a shield on their liability.
And is there immunity for the Department of Health and the Commissioner?
Is there sovereign immunity? That is not my...
I'm just confirming. I mean, my understanding is if somebody wanted to sue the Department of Health and they would name the Commissioner in that suit if they did something allegedly that the plaintiff was injured by. And so I don't see anything that suggests the Department of Health would be immune.
So I'm not the GoOps attorney, but I have reached out to the GoOps attorney. So I could, if it's helpful, I could read some of the information that I received from my colleague Tucker Anderson on this point, if that would be helpful. It says that with regard to the action of state officers, the state maintains immunity for lawsuits arising from harms caused by the state or state officers, except those that arise from an expressly granted right of action. For example, a statute authorizing a member of the public to file suit against the state or a state officer in a particular circumstance. The Vermont Tort Claims Act provides any person with a right of action for negligent or wrongful acts of employees while acting within the scope of employment. However, these claims are capped at $500,000 per individual and $2 million to all persons arising out of each occurrence of negligence. And the claims can't be brought by insurers. They have to be brought by the injured person themselves. But below, there's an important exception to the Vermont Tort Claims Act for discretionary policy decisions, like the decisions the commissioner would be making under H545. And that is that any claim based upon an act or omission of an employee of the state exercising due care and the execution of a statute or a regulation, whether or not such statute or regulation is valid or based upon the exercise or performance or failure to exercise or perform a discretionary function or duty on the part of the state agency or an employee of the state, whether or not the discretion is abused.
Where is that section?
That is from the Vermont Tort Claims Act.
Oh,
yeah. So taken together, it would be a heavy burden on the petitioner to recover from a state officer who's acting in accordance with the scope of the statute, assuming they're acting with due diligence and not misconduct. I think that's sort of the takeaway from that.
Committee, any questions?
Yeah, I got a quick one. Okay, does this same language appear for healthcare professionals who prescribe, dispense, and whatever else that's recommended by the CDC?
Can you ask me that again?
Does this same language appear if, in fact, a healthcare professional is doing the immunization with prescriptions or whatever, immunizations from the CDC?
What do you mean appear?
Right now, we're making exceptions for Vermont physicians because they may go along with the commissioner's recommendation for vaccines, right?
Mhm.
So if if this wasn't here, does this same language appear anywhere if they're following immunizations through the CDC?
I see. So if that language wasn't in the bill at all, if the immunization was covered under the federal vaccine injury program, there could be a liability protection for providers who are acting within their scope of practice. If the federal government decided to remove vaccines from that prevention program, then potentially providers would no longer have that protection. I will also say that the vaccines that are covered under the program, it's pretty specific about which vaccine it is, how long ago the vaccine was administered, what the types of symptoms they were. So I don't want to say it's sort of like a big list of all these immunizations and you had an immunization on the list, therefore you get compensation. It's still a process by which you hire an attorney and you see if you have an immunization that was listed within a particular, and you received the vaccine within a particular time period and had a certain reaction to the vaccine. Does that answer your question?
Can I ask it another way?
Please.
So prior to the Trump administration this time around, when the CDC was recommending and the state was recommending within the state's borders that we follow the CDC recommendations, did this apply to immunize people from liability if they were following the CDC recommendations? Or is this new language?
This is new language.
Okay, so there were protections for healthcare professionals prior to this, but they depended on the CDC.
Well, it depends on the federal vaccine injury program, what
Right.
is listed there.
So this is creating our own separate version
Yes.
of a liability shield.
Yes,
Okay,
thank you.
thank you.
Anything else? Any discussion on this? Do we need to make any changes?
And these are just
Anybody else?
recommended immunizations, not required,
Correct. This is
not
the,
making somebody do something
no,
they don't want.
this is the child and adult recommended schedule, but they're not mandated.
Any issues?
Is it kind of like the, 2-3 years ago, we passed the SHIELD law on, was it gender affirming care?
I did not work on that, so I
Okay, well, that's good.
would feel uncomfortable making a
No.
comparison.
It sounds,
There is
Similar.
similar language to this. This language in part was based on, in our opioid antagonist statute. If somebody is providing an opioid antagonist and they're acting with due diligence, there's a similar liability shield. So that's in part where this language was drawn from.
Wow, okay, dinner time too. Are there any other states that have this language or similar language to this?
I would have to research that and get back to you. I don't know off the top of my head. You do have the health department here. I don't know if the health department has an answer to that there. They brought the language.
Does the health department want to provide any?
Good morning, this is Jessica Shapano. I'm the policy director of the Department of Health. And there are several states that are working on very similar language that we've brought forward. I'm not sure that there's an exact replication of the liability protection language, but many states are considering giving more authority to their health department to make recommendations based on other authoritative sources in addition to the federal government.
So does our Department of Health currently make any recommendations? for immunizations?
We do, and to date, we have followed the ACIP recommendations, the CDC recommendations.
Got it. Okay, thank you. Committee, anything else? Any other witnesses we want to hear from or any concerns? Or are we fine with this?
I'm fine with it.
I'm not an expert in this field, obviously. Here we are again, being the tip of the spear. I just want to make sure that our spear is sharpened here as we move forward on this, but if you're taking a straw poll, I guess, I'll say yes.
Yeah, and we don't have to give a definitive answer today. I mean, if you want to sleep on it and do some additional research, I mean, it is just a straw poll. So I told Senator Lyons we'd get an answer from the committee this week at some point.
I'm not sure who else would hear from.
Department of Health,
Department of Health.
they brought forward the
Yeah.
language.
Vaccine skeptics.
All right.
Good.
Great. Thank you.
Yeah, you're welcome.
Thank you.
We can go on.